And welcome back to Era 3 of APUS History. In this video, we will be looking at the Constitution as it was written and how it was modified to address some of the issues that had been brought up in the debate about its ratification. So as you remember from the last video, the leaders at the Constitutional Convention created a new governing document through debate and compromise, which expanded the power and influence of the federal government. And they did this because of the failure of the Articles of Confederation. The government it had created was far too weak to be effective. The government this new document created was intended to address its failings and contained articles that addressed each of the key areas of government. This was also created as a living document, meaning that a plan was in place whereby it could be changed as new issues came up. Not so easily that mob rule was possible, but not so difficult as to stagnate the development of new laws to address a modernizing world. In the 230-plus years since the document was produced, it has been amended a total of just 27 times. One of the key things to understand about the U.S. Constitution is that it created a federal system of government. Federalism, which is what this system is based on, means that there is a sharing of power between the national government and state governments. One does not necessarily have more power than the other. They share power. Under the Constitution, certain powers are delegated to the federal government, like the power to coin money, to declare war, to regulate international trade. Others are left to the states to handle, like education, regulating local businesses, or maintaining fire departments. Some powers are shared between both, such as the power to tax or to establish courts. To make things slightly more complicated, though, there is the Supremacy Clause in Article 4 of the Constitution that states that national law is supreme to state law wherever they contradict. But there are only certain national laws that this would apply to, and these are called the enumerated powers of Congress, which are specifically listed in Article 1, Section 8. On the other hand, there is also the 10th Amendment, which says things not delegated to the United States, as in the federal government, are reserved to the states, which basically means that if it isn't listed in Article 1, Section 8, then it belongs to the state governments. Of course, there's still that elastic clause in Article 1, Section 8, Clause 18, which says that the Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. And this gives the national government quite a lot of flexibility in terms of what they can do. At least the Supreme Court has interpreted it that way over the years. Now, as for the second major theme of this new government, we have the idea of the separation of powers. This means that the new national government is separated into three branches. The legislative branch, or Congress, is responsible for making laws. The executive branch, that is, the president, is responsible for carrying out and enforcing the laws. And the judicial branch, or the Supreme Court, is responsible for interpreting laws to make sure they follow the Constitution. To make sure no one branch got too much power, the framers set it up so that each could check the powers of the other, a system known as checks and balances. For example, Congress passes laws, but the president must sign it in order for it to become a law. Otherwise, it can be vetoed, which is a check on the power of Congress. As a check on the president's power, his veto could be overridden with a 2/3 vote in both houses, which is actually quite hard to get. And the Supreme Court could still step in and overturn a law that both Congress has passed and the president has signed if they feel it violates the Constitution. And of course, someone has brought a challenge to that law through the court system. These are just some of the examples of the system of checks and balances. To briefly, before we wrap this up, I want to quickly go over the process of adding the Bill of Rights to the Constitution, as was promised to get the support of Virginia and New York in approving it in the first place. Even though Federalists argued that the Constitution did not need a Bill of Rights because the people in the states kept any powers that was not given to the federal government, Anti-Federalists held that a Bill of Rights was necessary to safeguard individual liberty. So one of the first things that the new Congress worked on was a list of rights that they felt should be protected. Ultimately, the House approved 17 amendments. Of these 17, the Senate approved 12, and so those 12 were sent to the states for approval in August of 1789. Of those 12, 10 were quickly approved or ratified, with Virginia's legislature becoming the last to ratify those amendments on December 15, 1791. And so the Bill of Rights is the first 10 amendments to the U.S. Constitution. The Bill of Rights is a list of limits on government power and includes the ideas of the Enlightenment and natural rights. For example, what the founders saw as the natural right of individuals to speak and worship freely was protected by the First Amendment's prohibitions on Congress from making laws establishing a religion or abridging freedom of speech. For another example, the right to be free from unreasonable government intrusion in one's home was safeguarded by the Fourth Amendment's warrant requirements. Other precursors to the Bill of Rights included English documents such as the Magna Carta, the Petition of Right, the English Bill of Rights, and even the Massachusetts Body of Liberties. In addition to the ideas of the Enlightenment, there was also direct connections to some of the things that Parliament had done leading up to the Revolution contained in those first 10 amendments. The Quartering Act, for example, was a direct precursor for the Third Amendment's requirements regarding quartering of soldiers in peacetime. Now, the two proposed amendments that were not approved in 1791 included a provision that would prevent members of Congress from voting themselves a pay raise and having it take effect in the same legislative term. That one actually was passed in 1992, 203 years after it was originally suggested. And the other one would have affected the number of members of the House and the number of people that members of the House could represent. That amendment technically is still outstanding. It would require a minimum of 200 members of Congress. Well, we have well over 400, so we're good there. But it also would have one member for every 50,000 people, which would put the size of the House of Representatives, as the population is currently, over around 6,000 people, which really is just too many to be practical, so that one will never pass. So there you are. That is what you need to know about the Constitution itself. Topic 3.9 of the APUS history curriculum.